How you?
I'm all right. How was your day?
Yeah. Not too bad. Went out to the yard this morning, talked to Stace. I'm pretty sure you remember him.
Yeah, he's still doing the law classes, right? I was talking to
Yeah,
Jay.
he does.
Said he's doing.
He does everybody's law work. He's
No,
been
the
down for
classes.
Yeah, he does classes, and what else? He used to work in a law library, but now he just does the classes. Talked to him for the whole yard. Talked mainly about the law. He got about, as you know, about 30 something in. 30, well, actually pushing 40, I believe.
Yeah.
So also a chess guru. I can't beat him. I think I beat him about maybe 2 times out of the 15 times we've ever played. He's top 3, so he's doing all right.
Okay.
So
good.
How was your day?
It's all right. Eventful. Yeah. I talked to Aaron earlier. He's
Yeah. How was he?
I mean, he's I don't know, man. He's different. He's been in since he was a kid, so it's
it's going to be ups and it's going to be down. So we just gotta. I mean, I just try to navigate as best I can, try to stay busy. So the last time we talked, right, I said I was going to talk about the jobs of the DA and the defense attorney. Now I mentioned something about dual obligation last time I talked, and I found my little notes, and that comes from the dual obligation comes from something called number 7 Corpus Juris Secundum, subsection 4, pages 801 and 802, and that's basically says, like I said last time, their obligations to the court and the public first, and not you. So
right.
That being said, that's a Latin term. I forget what that means, but that being said, the odds are against you from the very beginning. Do you remember the book Guilty Until Proven Innocent? You ever read that?
I can't say that I have.
Well, they get a couple values, but that's really how it goes. You're guilty, and you have to prove yourself innocent. So, like I said, the deck is stacked against you from the beginning. So you got this lawyer, the DA, and then I could throw the judge in there too. But they all belong to the same bar association, right?
They could also be playing golf together.
Golf, kids go to the same schools, you know what I mean, live in the same neighborhood. So it's you against them, basically. You against them. Well, you know how it is.
I remember my one lawyer, he had the judge's phone number on his cell phone. I just thought that was weird. Like, and the DA's, because he's like, let me call this DA real quick. Or he texted the DA and called the judge on his cell phone. I mean, I know they have to work together, but to what extent? And, you know, what goes on behind closed doors? And I have read cases where they'll say the district attorney went into the jury room, or they had a sidebar and I wasn't allowed to hear. You know, it's my case. Why can't I hear what the judge, the district attorney, and my attorney are talking about? And then, you know, they'll ask their attorney, and their attorney won't tell them. It's just, it's a little weird.
That's supposed to be part of the record.
Yeah.
Do you remember the paper I showed you when they had that conversation about the judge didn't want him to suppress any statements made by the defendant or alleged statements?
Mm-mm.
Do you remember that?
No.
I don't remember showing you that. Well, I think I mailed it to you. But yeah, the DA was in there. He said, yeah, Your Honor, the lawyer has adhered to your policy and didn't put any motions in to suppress any evidence by the defendant or any statements given by the defendant. What kind of backdoor stuff is that going on? But anyway, so DAs and defense attorneys. Now, the DAs and the defense attorneys are governed by the rules of professional conduct. If you get on your phone real quick and go to rules of criminal procedure, you click on, I guess, rules of professional conduct. Now, for the DAs, you got to see section titled advocate. Especially pay attention to section number 3, I think 3.8. But they got the bar association rules, and then they have the rules of professional conduct. Now, in there, sometimes they give a comparison. Sometimes you'll see the comparison between what's the other one they got to go by?
The ABA and the rules of professional conduct.
It's another one that they compare to. I can't. Hold on. I got the book right here. I got the book right here.
I remember people citing those the rules of professional conduct too. The judge has to act a certain way, and they almost never do. Especially when it comes to things like evidence, they really shouldn't be omitting a lot of the evidence that they do. And both ways, there's evidence that gets omitted that could prove a person's guilt, and there's evidence that they omit that could prove a person's innocent, it should be
Right.
everything out on the table.
Yeah. That thing I was trying to compare is called Code of Professional Responsibility. They got to follow by it. So they got a bunch of rules that they follow that they often don't. So like I said, the DA, he's governed by the advocate section in the rules of professional conduct. But also, if you read a case called, what is it, Berger versus United States, that breaks down how he's not supposed to just seek convictions and actually seek justice. Berger versus U.S., I think, from 1935. But my coworker pointed something out to me earlier while I was talking. He said, the word prosecute and the word persecute, if you look them up, they have some of the similarities in there. They have some of the same stuff. You froze for me. Sorry, you're back. Did you catch that last part?
Yeah. I probably didn't freeze. I was just motionless.
Okay. Now, as far as lawyers, same section, but you got to see sections, I think, 1 and 2, and it tells you all the guidelines you're supposed to do, how to communicate with you, how they're supposed to be good advisors. Also, something I've seen in the preamble to the rules of professional conduct, they have to, make the public known about a lot of stuff. They're supposed to share with the public the law as well. I didn't know that. I read that earlier today. How they're supposed to keep the public informed on certain things, I should say.
Like what? Like changes in the law?
It's to say a lawyer should seek to improve the law as a learned professional. Lawyer should cultivate knowledge of the law beyond its use of the clients, employ that knowledge in reform in law, and work to strengthen legal education. And in addition, lawyers should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions and constitutional democracy depend on popular participation and support to maintain their authority. So I didn't know that until I wasn't looking at the book here. I was looking on the computer. The computer had the same thing.
LexisNexis.
In the law library. Yeah, we got LexisNexis.
You have an outdated version. I can attest to that now.
Well, yeah, I got mine's is from 2011, so I gotta get a newer one. But a lot of times the numbers, as you know, don't change. So, but it's still, that's 14 years old, so I should probably try to get a new one or use one online somewhere, like cheap books from Amazon.
I was talking about
students, they throw theirs away.
I was talking about LexisNexis. Your LexisNexis there is out of date.
Oh yeah, hell yeah.
Really out of date.
They do updates. They do updates how often? And then when they do updates, some of the stuff still ain't in there.
The whole the software of it. That's not how it is out here.
Oh no! Oh, I don't know. So that's all I'm working with.
Like it's like futuristic when I went on there, and the version that's in there is like from 05.
Well, it's crazy because the county, they got LexisNexis, and it's probably updating. It's on the tablet.
The county's got the LexisNexis in Pennsylvania?
Yeah, the county prisons got, listen, the county prisons, this tablet I got, right? The county prison got, you see it has a microphone there, so they got the visits on there.
Yeah, I've seen that.
It's a phone. They got the visits, a phone, and they got the law library on there, because they don't come out much. Now, a couple cases, I know I gave a case on the DA. Now, a couple cases that breaks down the defense attorney, and what they should do, Powell versus Alabama, Johnson versus Zervers, and then you got Strickland,
Pierce,
the feds, Pierce for the state. But listen, Pierce. See, the PA Supreme Court can be so arrogant, and Pierce, you got to satisfy 3 prongs as opposed to Strickland.
Yeah.
Who are the feds who govern the state? They only got 2 prongs.
Yeah, so and when you look at those prongs, it's like there's I mean, you can meet all 3, but you can also, it's like ambiguous. That's the phrase I'm looking for. It's there's a prong, it's just ambiguous. You can interpret it any way. And in Pennsylvania, since you brought up the whole trial thing, you ever think about this, the right to a public trial? In Pennsylvania, they don't allow cameras. There's actually a lot of cases where people's families have been kept out of the courtroom.
Yeah, I didn't know that, but I know you definitely don't know no cameras.
That's how Bach actually got. That's how he got out.
I don't know Bach.
You know him if you've seen him. He used a case that was presidential, but I remember there were other people who were saying, "Well, that happened in my case," and because they were time barred, they couldn't raise it. So it's like
Yes.
your constitutional rights have a time limit.
Hmm. Yeah. So what way could the people get that done away with? On
The
the state
time
level
bar?
or on the fed level? On the state level or the feds?
Yeah, because you're talking about the what is it called? What do the feds call it? The AED something
I don't know
anti.
the Anti-Terrorism
Yeah.
Effective Death Penalty Act.
And that it's a 1 year, and it runs concurrent with your PCRA
State.
1 year.
Yeah, sure.
Yeah.
But how would a person or a group of lawyers say, hey, this thing is unconstitutional?
Right.
Whether it be on the state level or the fed, like who would it take to get that overturned? Because from what I'm told, I never read the act, but I heard the act is huge, and then they got that one paragraph thrown in there about the Hague.
And that's one of my ultimate goals from even doing this is to overcome that time bar, to do away with it. And I think the history of that piece, the PCRA, goes back to the Clinton administration. It was in '97 when it was enacted, and I think it was Joe Biden was a part of
He was on
the
there.
group that
crime bill.
created that. And if you remember, this was when mass incarceration really had been ubiquitous years before, but it really started picking up in the late 80s, early 90s. I think Bush, he had something to do with it. I forgot what it was he enacted. I can't remember what his phrase was.
Patriot Act?
What was it?
Patriot Act? Patriot Act?
No, it was, it was something that he got.
That's another one. That's another one that ain't constitutional.
The Patriot Act? Well, no, on the PCRA, though, with the time bar, and in that act, that first paragraph, it says, this act, the PCRA, subsumes the right to a habeas corpus, a writ of habeas corpus, coram nobis, and mandamus. And habeas corpus is Latin, and it means show me the body, something to that effect. And the reason why it was created, it was I believe in England. The story goes where people's husbands were just being like kidnapped by the police force and taken to these jail cells, and the wives were like, where's my husband, and why do you have him? So that's where the whole habeas corpus, that had been a part of our Constitution too, a right to a habeas corpus. It's basically saying, why am I here? I believe I have a right to not be here. I don't believe you're holding me legally, lawfully.
Right.
And then the PCRA Act subsumes that. It sort of suppresses that. And they'll say that there's you can still raise the habeas corpus under a de minimis, which is another term for a minimal standard. And I've seen one or two, and it was based off of like a parole thing. But to negate the constitutional right to a habeas corpus is by an act, it should be illegal.
Right. The Supreme Court should have struck it down as soon as they put it up for proposal. A guy came in the other day, and he says, I got him. This is not it's not cognizable under the PCRA. I said, well, good luck, man. I hope it works for you. He put in the state Hague challenge and something about his bill of information and his arrest. He said, hey, I shouldn't be here. I said, well, I hope it works out for you. But everyone I've seen so far, to date, they make him in the PCRAs. I think he put it in April, and he said he's still waiting. So hopefully, I don't know.
They don't even have to answer it. They don't even have to respond to it.
Wow. He put it in Clearfield County. Clearfield County put it in, so...
That's Judge Ammerman. He probably won't even respond to it. You might as well tell him now. He might as well request the docket sheet and then start pushing the envelope. And when you file a state habeas corpus or a mandamus or any of those motions, the court has the right to turn them into a PCRA. So if you file it and say, this is a state habeas, I'm citing this jurisdiction because I believe I meet this de minimis standard you guys outlined, they still can say, we're construing this as a PCRA and we're denying it as untimely.
That is
That you see
crazy.
that happens all the time.
That's crazy.
And I really believe the PCRA Act was created for mass incarceration. When prison really became a for-profit or corporation, you see a lot of political figures and their friends got into, the commissary. A lot of this, I guess you would say, like the stocks for prison. They invested into prison. They invested into our bodies, our
Some of
lives.
some of them own prisons.
Yeah, and the commissary,
Some of them own
Fifi.
private prisons. Like that's crazy. So I know we jumped ship real quick. So do you have any horror stories, or can you share? Not even if it's not personal. You work with a lot of guys in the law library, but the horror stories that you heard about lawyers and the representation.
Uh, Aaron, I was just talking to Aaron about this. And Jay, it's everybody has
Jay,
a
okay.
horror. Every single person. Show me somebody who says my lawyer did a fantastic job. I would love to meet
Not
that
too many.
person.
Not too
Yeah.
many. I mean,
And
the ones you're paying.
don't get me wrong, because and I know we've both said this. We should have opened with this because we both agree that not all attorneys are bad, and I'm not
No, not
saying
all.
that they all do bad things. I know a lot of them are overwhelmed, overworked. I do paralegal work out here, and it's exhausting, but you still have a code to live up to. It's like a doctor when you take that Hippocratic, what is it called? Hippocratic
There you
oath.
go.
Yeah.
Yeah.
I mean, same thing for an attorney. You're defending somebody for their constitutional rights.
Right. They take a oath to honor, obey, and support the Constitution, and
Right.
a lot of times
Same with
they
the
don't.
judges.
Like a lot of all elected officials do it, whether it be a DA. I don't know if the lawyers have to do it, but I know the DAs do. Shoot, the president had to take oath. He's supposed to honor and obey to support the Constitution, but anyway, I ain't gonna talk about him.
I don't
But
know. I don't know where exactly in the annals of our history did our Constitution become just like null and void, like misinterpreted, like a piece of paper of guidelines. But it has. I mean, right now the Constitution is just applied when it wants to be, when the judge wants it to be, the person who has jurisdiction over it, however they want to apply it. And I'm sure you can agree to this. The Constitution has become so diluted. Our rights have become
of course,
diluted by case
of
law,
course.
because these case laws are what outline a standard for our rights. And there's a case law to substantiate any claim we have, and there's also an opposing case law for the same claim that can suppress it.
That's why I told you I don't like using them. I rather, if you have to
have no
use, but
choice.
I prefer to use a statute or a rule because it is what it is. Now with the case law, you got one to say this, and then you got another one come around 2 years later and say, "Oh no,
Yeah.
we're overruling that, or we're just not going to use it. We're not applying that in this case." Sometimes they do a
Yeah.
case by case basis. Make reference to the old one and say, "Oh, that doesn't apply here." It's crazy. It's crazy.
The
Now,
only obvious way to get rid of that, to fix that, is to get rid of all case law and create a standard by statute for all that. And it wouldn't be that hard. It's for Brady violation. I mean, obviously, a district attorney, should not be able to withhold evidence from the defense. We don't need a case law to say that. It's
right.
You know what I mean? And then same thing
Right.
for every claim that there is. There shouldn't be
Yeah, you're right.
case laws, because
Yeah.
the judges who are governing those case laws, who are making those case laws, aren't all scrupulous. I mean, we should know that by now.
Right. Yeah. And we don't even know they could be biased for all we know on certain cases or certain types of cases, and you would never know. You would never know.
I had a federal judge, and they all talk about him up there, up in that county, Pesto. The federal judge,
I already knew.
I mean, he basically called me a drug addict when I presented my lawsuit for drug addiction, and denied it, dismissed it. And then his district judge, he was considered a magistrate. The district judge adopts what he says. I followed the same thing in the Commonwealth Court. The exact same thing, verbatim. I didn't retype it. I just I whited out the top, and instead of, the district court, I put Commonwealth Court. And they ruled in my favor. So that right there shows you that it's based off of, a judge, whatever judge you get, right. And the law shouldn't be dependent on which judge you get. It should be dependent on the law.
Now, I want to go back to what you said. You mentioned the Constitution, right? Now, when it was originally written, it didn't include people like us, the poor people. It was for the 55 people who gathered together down in 1787. Those 55 men that gathered, right? They were all property owners, lawyers, bankers. So if they're going to start this club, right, it's basically a for us, by us. So if we're going to start I'll give you an example, a motorcycle club. If me and you start a motorcycle club, we're writing the Constitution. The rules are for who? Me and you, right?
Yeah.
So if they're the founding fathers, and remember, they excluded poor people, they excluded people who didn't own property, black people, the Native Americans, and of course slaves. Oh, and women, because remember, the women couldn't vote the suffrage. Women, so they excluded a bunch of people.
People forget that women didn't have rights until just 100 years ago.
Yeah, they just, what amendment is that they started, they let them vote? I can't remember what
that's. Like the 21st, yeah.
20th, 21st, or 22nd, I can't remember.
That came after alcohol, the abolition of alcohol.
I want to say in the 60s that came along.
What, the rights for women? No, that was in the 20s.
The 40, all right, to vote, all right, 40s, okay, but yet still.
No, the 20s.
How many years
women's rights to vote was in the 20s. And the amendment is in, I think, near the 20s.
Okay. Either way, it took forever for them to get a right to vote. Since
you brought up the founding fathers, the 55, I'm assuming you mean the ones who signed the Constitution.
Right.
John Hancock, the biggest signature, if you ever read his biography, you'll see why the whole revolution started. And because if you compare it to what's going on in our country today, taxes, they didn't want to pay those outrageous taxes. And John Hancock, I think it was, who had a timber farm, and the King George the Third, he got the best timber from this guy's farm, and for free too. That was just the tax. This is my land, you have to give it to me. They came together and spurred us poor people up, got us all excited to fight their war, so they didn't have to pay King George. I mean, that's really how I think of it.
Yeah.
We pay more today in taxes. Of course, you have to do the monetary equation, but it still comes out to we're paying more today than they were paying, per capita or whatever. Right. I mean, should we pour over some ships of tea or whatever the commerce is around that our government uses? Well, the government's commerce that they use is inmates. No, don't get me started. I'm gonna have to cut that one out. I get radical about this, man.
Yeah.
Because it's hard, man. It really bothers me, and it bothers me that it doesn't bother other people as much.
Did I mention a couple of them were lawyers of those 55 men? Did I mention some of them were lawyers?
Go ahead.
And signing that thing? Yeah, I mentioned. All right. So listen, I'm reading. I think I told you the book. I'm done with it now. How to Read the Constitution and Why. And she says something interesting that some of the, I don't know if it was a legislator or a senator, proposed that they hold another constitutional convention. Because people like Trump are saying it's archaic, and he says it's bad for the country. And according to her, it's not that far off that they'll hold another constitutional convention at some point because of the age of the Constitution. That, to me, that's scary, because I can almost guarantee some of them rights are going to be stripped away, because they're stripping them away now with the Constitution that we have. So imagine having another convention and then scrapping that Constitution and doing another one. Remember, that's how they did it back then. The first was the Articles of Confederation. Then they didn't like that. They weren't getting along with that. Or they didn't, they just seen holes in it, and then that's when the Constitutional Convention came because they were supposed to just fix the Articles of Confederation, but then they was like, nah, they just scrapped it, and then that's when they came up with the Constitution. So according to her, it's not far off. Kim Whaley,
But if you look at the history of countries with a constitution, our country's the only country who hasn't amended the constitution. We have the oldest constitution. All the other countries that have constitutions have redone their constitution.
Oh yeah.
Yeah. I believe our constitution needs to be redone because that would sort of give us a new standard. I mean, and I honestly believe that the reason why they don't is based off of the Second Amendment and the, what is it, the 14th Amendment, the where they abolished slavery, but they threw in that little ending. The slavery is abolished, except if you've been duly convicted.
Right. Yeah.
So,
yes, 13.
The 13th.
But yeah, you said the second. So you said the second
due process. Yeah, then the Second Amendment, the rights to guns, which the manufacturers of guns, they have a lot of money in lobbying.
Well, yeah. Well, that's what scares me because now, if you scrap the old one and you get a bunch of these people to get to the table and start a new one, those same people are going to be the same type of people back then. They're going to be the people in power who are creating it. It's not going to be nobody from my neighborhood or your neighborhood sitting at that table talking about it. Right. Remember, they didn't want a total democracy back then. Like, you know how they say we have a democracy, but they didn't want a full democracy because a full democracy would be majority rules. You know, if it's 100 people, 51 people agree this way, the other 49 get screwed. So that's why they came up with the whole republic thing where they elect officials, and then you gotta elect them officials, and they come to the table. They're supposed to bring your grievances or problems to the table, which they don't. It's just for their own agenda.
Yeah, so, I'd love that. Tell anybody in there to cite your constitutional right. The courts look at you like you're crazy.
People know the First Amendment and the Second Amendment. That's the only one. If you're not in prison, they're going to know the First and the Second. That's all they're going to know. But if you've been through the system, of course you'll know the Fourth, the Fifth, the Sixth, and the 14th.
A lot of people know the Fifth Amendment. That's sort of like a meme out
here. Keep quiet. You know? Yeah, because I plead the Fifth. All right, so you're right. I plead the Fifth. So First, Second, Fifth. That's about it.
Yeah. But yeah, and you know, the Eighth Amendment, the right to bail.
Unusual punishment.
Well, and the right to bail. You know how many people are in the county jail now? Remember, you had just brought this up. Innocent until proven guilty. So when you're arrested and you haven't had your trial yet, you're technically supposed to be considered innocent until you're proven guilty. But for some reason, they put you in jail, and then they give you a bail, so you have to pay, and that separates you by class right there. A lot of us can't afford it. But that Eighth Amendment is supposed to explain a person should have a bail that they can afford because they're still considered innocent. They haven't been found guilty yet. So they need to have a bail that they can afford. But we don't do that in our country anymore.
They don't even give you bail sometimes.
I didn't have a bail. I was arrested with drugs and they gave me no bail.
What? On a drug case?
Yeah, man. There was I was raising and I had a high-paid attorney. It took me 6 months, I think, just to get a bail hearing because every time he requested a bail hearing, the district attorney filed a motion to dismiss. Wow. If I showed you my docket sheet, the first 6 months, every other week, it's motion for bail, motion to deny a bail hearing. Motion, and it was just back and forth 6 months until finally I think it was like a $500,000 bail. I bailed out.
Wow, for drugs. So,
yeah.
They made it seem like he was selling. You had 50 bricks or something on you.
Yeah, but, like I was El Chapo.
Pennsylvania used to have. You used to be able to bail out for murder in Pennsylvania. There's some people say in their county you do. I don't know, but I know. In Philadelphia, anyway, I don't think you're getting no bail for murder. The last person that got bail for murder, I think, was Ira Einhorn, and you see how that turned out.
You talking about first degree?
First degree, yeah.
Or are you talking about homicide in general?
I don't think there's no bail for first degree. I don't think you're going to get no bail in first degree in PA.
Because I know
Like I said,
somebody
the
who's
last
out right
person,
now who's charged with homicide.
yes, they got criminal homicide and they got murder. You know the
They even have
definitions.
negligent homicide.
But that's
And
yeah.
you get a
Homicide just means you
$10,000
caused the
bail for
death.
negligent.
Yeah. Yeah, I didn't know that.
But I mean that
You
means
know-
that's an accident. That's an
Right.
accidental
You
death.
didn't mean to it. Right. You didn't mean to it.
Theoretically, right.
Yeah, homicide means the life was taken, so it's negligent.
Right.
So negligent homicide. Yeah. Yeah. I was let me see. Did I think I covered everything with these lawyers?
No, you didn't cover the constitutional right to an attorney. In the federal constitution, what is that? The Sixth Amendment. You have the right to assistance of counsel, and
Right.
then
It is a six. Effective assistance.
and then
as
in
well.
Pennsylvania, it's Article 1, Section 9, I think.
I believe it's. I don't know which one it is. I don't have it. I usually have my book in here.
But
with me,
those
I
are
can't remember off the top of my head.
constitutional rights to counsel. And now,
Right.
does that mean that they have to be effective?
It's supposed to be, because they always cite it when they cite anything to do with the effective assistance counsel. They always mention the Sixth Amendment, but they're supposed to be.
And
Keyword
again,
supposed.
that's governed by case law. The standard for your representation is governed by case law, and there's so many different ones that they can cite. Like you named a whole bunch of them.
Well, yeah, like I said, the key ones I like to cite when I cite ineffectiveness is now. I said Powell versus Alabama. They don't use the term ineffective. They use abandonment, which I believe is stronger. They say the moment he abandons you, the trial is without jurisdiction because you don't have a lawyer. So Powell versus Alabama and Johnson versus Urvis, that's the one that says the law is intricate and complex, and you absolutely need a lawyer if you're a layman.
Yeah, and who's not? If I would have known the law when I went to court, I would have been out 7 years prior to my release.
What did I say last time? I said it would be so good if schools, more schools I should say, because my daughter says she had civics. She didn't go to a public school. But if more schools had a civics class and a law class, a law 101,
yeah.
What does it take to get arrested or something like that, or what can keep you out? Just something for the kids instead of this school to prison pipeline that they have now.
Yeah, we need to start adding in how to fix it, because that a lot of what goes on in society right now is complain. I don't like the way this is ran. I don't like the way this is ran, or we're doing this. Offer a suggestion, and that's right there. We need to explain, or in the schools, and a good example of that is going to be. I remember when I was in there. I remember watching the news. And in Chicago, Chicago is a very violent city. Their district attorney came out with some sort of mandatory sentencing again for possession of a gun. And his goal, he said on camera, was this is going to stymie people from wanting to even possess an illegal gun. And I thought, well, how are they going to know? I mean, I had a gun, and I mean, I never got a memo saying, if you get caught with this, by the way, you know what I mean? Yeah. It sounds good, I'm going to raise the sentencing guidelines for this, but we're not going to tell the people, who are doing it. Just whoever's watching this news right now knows. That's it.
The amount of time you give a person doesn't deter anyone from doing anything. Look, people know you have the death penalty, and they still do stuff, knowing that the death penalty is a possibility if you do something heinous. So that's not going to be a deterrent. More time. That actually falls on the taxpayers. You putting these people in jail for all this time. Like, remember, the key is supposed to be rehabilitation, not suffering. Like, if you're there to do, if you're there to be rehabbed.
Suffering.
Huh?
Well, because you said suffering, I thought of the 8th Amendment. Cruel and unusual suffering. It's in the Constitution.
Yeah, this is ludicrous. Something I wanted to say, I forgot that fast. We talked last week about, I think we said something about Department of Corrections now. They have a title, correctional officer, but you and I know they don't do nothing but open doors. They don't do nothing with our planning. or nothing, right? They're not here to correct.
Oh
I
God.
know you're trying to hush me up.
No, I'm going to tell you this, man. I just read the law. A correctional officer is considered an officer, and they have the jurisdiction and ability to perform an arrest. But it has to be. It's within there. That's their jurisdiction. But that's how important their positions are to be construed. But I mean, what sort of training do they have?
Not anything to do. They do nothing at all. I'm just saying their title should be different because
Yeah,
a CO
they have too much
don't have
power.
nothing to do with our rehab.
Right.
Oh, listen, man, we about out of time that fast.